Hello everyone, welcome back to the English Law channel. So I'm going to look at mortgages now, and first of all how they're created. So with the LRA 1925 had various laws about mortgages. We don't want to go into those because remember that's been replaced by the Land Registration Act 2002. That's the present law. So in registered land, a legal mortgage of land is created by charge through a legal mortgage, and you have to use a deed to do this as per the Law Property Act 1925 section 52 and indeed section 1 of the Law of Property Miscellaneous Provisions Act 1989, and then has to be a registration and land charges of the land impacted as per the LRA 2002 section 27. Then it's a registered charge. So the legal rights attached to a mortgage will only pass registration. Only once they pass registration is this effectual. In the end, this is going to be done electronically. Section 24 of the LRA 2002 says that only the registered proprietor, a person entitled and registered through a transfer, or the owner before the first registration can create a legal mortgage. This is the only way in which registered land can be mortgaged. It's a charge by deed by way of a legal mortgage, right? That's the demise of a leaseholder's estate as per section 23.1. So let's look at equitable mortgages, and that is all those mortgages of registered title land that are not on the register. So the mortgage of an equitable interest, such as a life interest arising under a settlement, or indeed a tenancy in common, is always equitable and is made by a conveyance of the equitable interest with a proviso for reconveyance. If it's not made through a will, then the assignment has to be made in writing by the mortgagor or his agent, authorised in writing too, according to the LPA 1925. So the informal mortgage of a legal interest is regarded as a contract for a mortgage provided for the requirements of the LPMA 1989, Section 2. And if these are fulfilled, then it has to be made in signed writing, of course. Then the contract is indeed specifically enforceable, and it's seen as in equity as a mortgage. So looking at equitable mortgages, it involves the deposit of title deeds. So this is by way of security. In reality, it's usually accompanied by a memorandum under seal. The LPMA 1989 took effect, and then simply depositing the title deeds is not enough to create a mortgage unless there's a written contract too, and that was found in United Bank of Kuwait against Saab 1997. An equitable charge is where property is appropriated to the discharge of a debt or any other obligation. So the LRA 2002 says that any mortgage that's entered on the charges register is indeed equitable as per sections 25 to 27. So it can be enforced, it has to be registered substantively. Then, in whatever form it is a legal charge, section 51. In unregistered land, the means for creating a mortgage are as per the 1925 rules, though after 1997, creating the first legal mortgage means first compulsory registration if it's unregistered land. So now the LRA 2002 section 4.1 says the mortgage of unregistered land causes the registration of the mortgage estate and the mortgage itself. Let's look at the registration of mortgages. If the land is unregistered, there are different types of mortgage that are registered as land charges pursuant to the LRA 1972. So there are three different kinds. There's a puny mortgage. That means a legal mortgage which is not protected by deposit of deeds. That's the first legal mortgage, usually hold title deeds, and they're entitled to do so. That's a Class C1 land charge. It could be a contract for a legal mortgage, an estate contract, or a Class C4 land charge, and finally a general equitable charge as per Class C3, a land charge as per Section 2.4 of the Land Charges Act 1972. If an equitable mortgage is protected by deposit of deeds, then it's not registrable as a general equitable charge, and probably not as an estate contract either. So the provisions of these acts are vital when you're thinking about the priority of mortgages, because the mortgagee of an equitable interest has to give notice to the trustees so he can secure priority under the rule found in Durl and Hall 1928. After 1997, first legal mortgages cause compulsory first registration. So before the LRA 2002, if the land was registered, legal mortgages and charges had to be perfected by entry of notice on the on the register, and there had to be a registered charge against the charge titled, and the issue of the charge certificate. So to the chargee. Until a mortgage became a registered charge, it used to be in equity and couldn't be overridden as a minor interest unless it was protected. Could be overridden as a minor interest unless it's protected by being put on the land register. Interest that would have been registerable as per the LCA to 1972 if the land was unregistered then took effect as minor interests, and they had priority according to the date of entry. A mortgage lien, as in like link in French, through deposit was possible under the LRA 1925, that's section 66. So there was a big change in the LRA 2002. Substantive registration is now obligatory when a registered proprietor gives a mortgage or a registered charge is transferred or subjected to a further mortgage. Registration against an effective estate is very important, as per section 27.2, for the mortgage to be effectual as a legal charge. If there is no such registration, then full legal remedies are not available. If this first registration with title absolute is subject to all mortgages and charges extant at the time of the first registration, as per section 11 or section 4.1 of the LRA 2002, a grant of a mortgage itself can cause registration. If the land is registered, then the mortgage is entered on the register and is bound by all the previous interested land. So let's look at the position of the mortgager. There is clearly a dissonance between the mortgager and the mortgagee. If the mortgage is a contract, and the freedom to contract is a crucial commercial principle. So more and more the courts want to protect people who enter into the contract on unconscionable terms. So now there are more non-commercial mortgages. There are laws to protect mortgages. So a mortgage is the right to redeem a debt. Mort as in dead and gage as in pledge. So make the pledge dead. You paid off the debt and now you become the legal and equitable owner of the land. So you're reclaiming the land. The courts have principles because they can strike out attempts to delay this right to redeem the mortgage. Anything that's seen as a clog or a fetter, as in trying to make it more difficult to redeem the land, will be struck down by the courts. So in history, the law of mortgages was about the need to protect the mortgager from harsh terms. And the core principles were set out at a time when mortgagers often found themselves in a weaker bargaining position against mortgagees. But the problem nowadays is the degree to which the principles should still operate. Especially in commercial mortgages, protection from a mortgager is not very extensive. And some people think that this inequity of bargaining power in domestic mortgages needs to be addressed more. So equity has always said that the security aspect of transaction is important and has rules to protect the mortgage's equity of redemption. Moreover, protection is given by a common law doctrine of restraint of trade and through the Consumer Credit Act 1974 and the Consumer Credit Act 2006. The Law Commission said there needed to be reform in this area and produced a report in 1991. So at common law, there's a right to redeem and the mortgage is set within 6 months of the date that the mortgage is granted. But equity gives for the date to be set later on, up to 25 years later. And if there's an attempt to restrict the ability of the mortgagor to redeem the mortgage property, such as an option to purchase, the court might regard this as something which is unduly onerous, and seeing this is trying to change the core of the mortgage. So a provision about giving the mortgagee an option to buy the mortgaged property is usually held to be a nullity. But the mortgage is a contract, and remember there's freedom of contract principle which courts are keen to honour. So if the courts think the option to purchase was freely entered into as a separate agreement and it was not contingent on a mortgage contract, then the courts will probably say that still stands. Siamal against Jarrah Timber and Wood Paving Corporation Limited, 1904, Reeve and Lyle, 1902, are examples of this. So if you look at a case called Jones and Morgan in 2001, there was a nursing home which could have been repossessed through an agreement. An agreement was reached and it didn't happen in the end. But the mortgage agreement said that the lender had the right to buy half a share in the mortgaged land. One judge in the Court of Appeal, a minority one, thought the agreement was reached outside of the mortgage. And after the mortgage was completed, and he said it's not a clog, and this ought to be upheld. But the majority of the bench disagreed, and they struck down the offending term, saying that's a clog. So in the process, it's obvious that they disapproved of the precedent that they were obliged to enforce. Okay, the Master of Rolls, Lord Philip, said, the doctrine of a clog on the equity of redemption is, so it seemed to be an appendix in our law, which no longer serves a useful purpose, and would be better excised, close quotation, as in got rid of, to excise, customs and excise kind of thing. So likewise, you can see what the Court of Appeal was saying in Warnborough and Garmite 2003. The court said that the fact that an option to purchase the property is given by the mortgagee is granted doesn't mean it's a clog. It might be, the court might have to look at the real nature of the bargain between the parties. That's enough to begin on mortgages. Toodaloo.